The criminal justice system in Indiana, a step-by-step guide. So first is before your arrest. This is when maybe a police stops you and they're questioning you. What rights do you have if police stop you and they question you? People have all heard of Miranda rights. What are your Miranda rights? When must you identify yourself? Is this a consensual encounter versus what we call a Terry stop? So first, police can stop you and maybe they're talking to you. This can be what's called a consensual encounter. And in a consensual encounter, maybe an officer is just walking by you and he sees you're holding a cup of coffee. And so he says, hey, where'd you get that cup of coffee? He's just asking a question. This is a consensual encounter. You don't have to answer that officer. You can walk away from that officer. There's no issue. But what if an officer is actually stopping you? He's telling you, hey, you can't leave. You have to stay here. Or maybe they're performing a Terry stop, which is a Terry stop is basically they can do a quick search of you. Officers' articulable suspicion is required for them to at least initially stop you. And then they're going to need probable cause if they're going to arrest you. And then additionally, search and seizure laws. When do police need a warrant? When can they search without a warrant? And what do you do if your rights are violated? These are all in the first step of that before you're arrested. These are all factors that you have to consider. So next is the arrest process. If you're being arrested, did the police need a warrant to arrest you or did they not need a warrant to arrest you? And what happens after you're arrested? What happens when you're taken into custody? Well, generally, if police see you commit a crime, right? Let's say you punch someone in the face right in front of them. They're not going to need a warrant to arrest you. They can arrest you right there. But let's say maybe this is an investigation into some wrongdoing. And so they've got texts and they've got Facebook messages and all this from this investigation that they're doing. Well, in that scenario, they might get a warrant to arrest you or maybe search for something. When you're taken into custody, police are going to tell you, hey, put your hands behind your back, generally, right? They're going to put you in handcuffs. And when you are arrested, is generally when you're going to be read your Miranda rights. And everyone kind of knows what your Miranda rights. You have the right to remain silent. Anything you say or do can be used against you. You have a right to an attorney. Those are kind of the big ones. Your right to remain silent and your right to an attorney. They'll read the whole thing to you, but police have to tell you that. They have to tell you what your rights are if they're arresting you. So the next, you've been arrested. So step 3 is release from custody. I've been arrested. I'm being put in jail. How do I get out of jail? Well, generally speaking, there is a bond or a bail process, and bail is set or bond by a lot of times what you're arrested for, what kind of crime it is, and then county by counties can vary. So in Marion County, for example, which is Indianapolis, there's a bond schedule. So any misdemeanor is kind of open to argument before the court, and the court's going to look at your criminal history, and the court's going to look at what you're charged with. And then after that, they kind of have set amounts that can go up and down based on certain things. So if it's a level 4 felony and you have an extensive criminal history and there were multiple victims and things like that, it can cause your bond or your bail to be different. And the difference between the two is bail, that is a cash amount. You're paying that to the court. That's your money. You're paying it to the court. If you have a $10,000 bail, that's $10,000 in cash you pay to the court. If you have a $10,000 bond, you pay 10% of that. So you're going to find a bail bondsman. They're going to pay the $10,000 to the court. You're going to pay approximately $1,000 to that bail bondsman. And once your bail or your bond is posted, you can be released. Now, if your car has been taken or your license has been suspended, then you also have to think about that. If your car has been impounded, depending on why it's been impounded, might determine whether you can get your car back. If this was an OVWI and your car was impounded, you can probably go get it back fairly quickly. If your car was busted in a drug sting operation, then depending on what officers might have had to do to that car or the different facts and circumstances, you might not be able to get it back. Additionally, there are automatic license suspensions that happen in OVWI cases or DUI cases. And so you have to think about that. Is your license suspended? What kind of suspension is it? And then whether or not you're going to be able to get specialized driving privileges. Step 4 is your first court appearance. And this is your arraignment or your initial hearing, as we generally call it in the state of Indiana. What happens at this initial hearing? You're told about your charges. A plea of not guilty is entered on your behalf. You're told about initial court decisions. Maybe the court's going to give you your next pretrial date, your bench trial or your jury trial date. They're going to give you what's called an omnibus date, which is something that your attorney needs to know about if you hire an attorney. And also, depending on what you've been charged with, will also depend on what court you go to. So in different counties, many counties have maybe major felony courts and lower level courts. So you're not going to, if you get charged with a misdemeanor, you're not going to go in a major felony court where that judge does a bunch of murders. You're also going to be told about your right to counsel. You have a right to an attorney. That's going to be told to you again at your initial hearing. And this is when, if you can't afford an attorney, you're going to be appointed a public defender. And if you can't afford an attorney, you let the court know that you plan on hiring an attorney. And then also at this initial hearing, you're going to be told if there's any no contact order. A no contact order basically means you cannot have contact with someone. And if you do, new criminal charges can be brought. Some people think of this as a protective order, and no contact order and protective orders, as we've discussed in other videos, almost the same thing. One is just criminal and one is civil. So step 5 is if your license has been suspended. And what do you do if your license has been suspended? Can you challenge that? Can you get your license unsuspended? If your license was suspended as part of an OVWI for a refusal suspension, then maybe your attorney needs to file what's called interlock in lieu of a suspension. And that is when, instead of the court suspending your license, they impose interlock. If this wasn't a refusal suspension, then maybe your attorney can file for specialized driving privileges. And these specialized driving privileges will allow you to go oftentimes to many places, almost as if you weren't suspended at all. But there will be some restrictions. And a lot of that is case by case, and also whether you have a criminal history. So the next is step 6, the court process. And this is oftentimes the lengthy process. This is what takes so long in the criminal justice system, and what's going to be the bulk of what your attorney is doing handling your case. The first is discovery, obtaining evidence from the prosecution. So the prosecution has to send initial discovery. Initial discovery includes charging documents, your criminal history, all the initial evidence, the probable cause affidavit. But then additionally, there is going to be generally more discovery. Generally, the prosecutor's office won't have body cam right away. They're not going to have blood work. They're not going to have DNA. They're not going to have fingerprinting. They're not going to have external videos. All of these things are things that might take the state time to compile and then send to you or send to your attorney. There's also negotiation with the state that happens. So oftentimes the state and your attorney are going to discuss what a potential plea bargain might look like. But the state and your attorney oftentimes aren't in great positions to fully discuss that until more discovery has been completed, because your defense attorney doesn't want to tell you to take a plea if new evidence might show that your case is actually stronger. And on the flip side, the prosecutor doesn't generally want to offer a plea until they know what their evidence is going to show. Additionally, there will be pretrial conferences. This is kind of just checkups where the court is just wanting to know, hey, is anything happening on the case that the court needs to know about? And then during this period of time is when you discuss with your attorney, what are your options? What might a plea deal look like? Could we plead to this over this? Maybe the plea that the prosecutor sends is for this and you would like this. So different negotiating what that plea might look like, or what a trial might look like, whether that is a bench trial or a jury trial, what it might look like. Step 7 is then going along with the plea, and that is plea bargains and what alternative sentencing can look like. Most cases in the state of Indiana, and most cases in every state, will result in a plea agreement. There are different types of plea. At your initial hearing, you're going to have a plea of not guilty entered in your behalf. In Indiana, generally your options are not guilty or guilty. We don't do things like a nolo contendere plea. You're not allowed to do that. So in Indiana, it's guilty or not guilty, or a diversion. A diversion agreement is basically a pretrial program where basically the state of Indiana is saying, hey, look, if you do certain things and you complete those things, we will agree to dismiss the case. State of Indiana has a diversion that basically is for misdemeanors, and then they also have a felony diversion program. Generally speaking, diversions are offered primarily for misdemeanors. There's some things that they can't be offered for. For example, an OVWI or a DUI, you cannot get a diversion on that. But let's say this is your first time committing a misdemeanor, it's criminal recklessness, or it's a misdemeanor battery, or it's a misdemeanor theft. You've never been in trouble before. Your attorney might be able to negotiate a diversion agreement. And then also restitution. Let's say you stole $500 from someone, right? That's a misdemeanor. Maybe your attorney negotiates a diversion agreement, but you have to agree to pay that $500 back. So restitution is a requirement. The next thing is motions in criminal cases. And this kind of goes along with just the general kind of process of the case moving along. Maybe early on, a motion to suppress evidence needs to be filed. This is when the defense is challenging unlawful searches. Did police just bust into your home without ever getting a warrant or without ever being invited in? Then maybe you can challenge the legality of all of the things that they might have found in your home. Motions to dismiss. Oftentimes, they don't get filed until much later on. There's other common motions, right? A motion for a speedy trial or an early trial in the state of Indiana, a motion for a change of venue, discovery motions. Maybe you need to compel discovery. Maybe the state's not sending you something, or maybe there's a third party that needs to send a video, for example. There are different discovery motions you might need to file. So step 9 is the trial process. There's either a bench trial or a jury trial. A bench trial is just where you do the case in front of the judge. And there's no jury. The state will present its argument, defense will present an argument. But generally, when we talk about the trial process, what most people think about is the jury trial process. So we'll do the jury selection. What is voir dire, how we do that. Trial steps. There's opening statements. There's evidence presentation. There's cross-examination. There's closing arguments. Also, when you get to trial, penalties. So if you are found not guilty, great. You leave. You're good to go. Your case is resolved. If you were to be found guilty, are there sentencing enhancements? Are there mandatory minimums? For example, if you're a repeat offender of something, you might have requirements the judge has to give you at sentencing. And so those are all things to think about in the trial process. So step 10 is sentencing and post-conviction consequences. So again, as we just discussed, when you're at sentencing, how does sentencing work, right? There is jail time, there's mandatory sentences. So if this is your third OVWI, you are going to mandatorily have to do 10 days in jail. Or if this is a level 2 felony, there are minimums that the court must impose for executed time. So you'll have your sentencing. The judge will tell you what your sentence is. DOC, jail, home detention, probation, all of these things are possible things for sentencing. And then when you're released from jail, did you have to go to jail at all? Are you on parole? What kind of release is there once you get out? Maybe you're on home detention and you'll be on community corrections. Or maybe you're on probation. What are your conditions of probation? What are the rules that you have to follow? And then you have to think about the consequences of violating any of those rules. And then the final step is the appeals process or clearing your record. First, the appeals process, that is just how you challenge a conviction. Now, if you go to trial and lose, you have a right to an appeal, and you can appeal almost anything at trial. If you take a plea, your right to an appeal becomes very limited, because by taking a plea, you are agreeing to a lot of things, including that you committed the crime and, generally speaking, to your sentence. But after you have pled guilty or after you've lost a trial, you can potentially try to have your criminal record expunged. There's different time periods for misdemeanors versus felonies, but you can try to get that expunged and potentially have nothing on your record after a decent amount of time. So these are the kind of 11 steps that encompass the Indiana criminal justice system. If you have questions about any of this, or you need an attorney that is experienced in working through all of these steps, explaining these steps, really helping you understand what part of these steps you're at and what are the next things that you need to do, call us at the Marc Lopez Law Firm at 317-632-3642. And remember, always plead the fifth.